Let's see how is this practice in India, and I invite here Manta. Please, Manta, the floor is yours.
Thank you, Claudia. It's very interesting to hear the regime in Brazil, and thank you, Ning Zhang, for explaining the situation in China. Just picking up the last point while I'm sharing my slide, is in India, there has been cases of grant of compulsory licensing and also denial of compulsory licensing. So unlike China, where there has been no compulsory licensing, we have instances where both the situations are there. So can you see my slides?
Not yet.
Not yet. One moment, just allow me, please.
Mm.
So, okay. So, while I will keep on trying, you please ignore the effort which I'm trying to put the slides on screen. But in the meanwhile, I can tell you that the objective behind, compulsory licensing in India is to balance the right of the patentee vis-a-vis the public right to avail the yes, it's there. Can you see here?
Yes, we can see the slides.
Okay, perfect.
Yes,
I'll make
just
it
put in the full. Yes, full. Thank you.
Sorry. Just one moment. Yes, so I think it got frozen and now it's there. Okay, perfect. Sorry about it. So it's very much similar to China and Brazil. And I was trying to tell that it's a balancing act which came from 1931 from TRIPS agreement. Why did this provision came into existence is that there are developed country, there is developing country, and there were underdeveloped country. Particularly in the case of pharmaceutical, where the genesis of compulsory licensing took place, the idea was that though the patent which is granting you the exclusive monopoly for a certain period of time, but in the case where the need arises for the mankind, for the public policy or public health or public interest, there should be a provision where if the patentee is not agreeing voluntarily to grant the license to the needy or the company, there can be a provision to compel the patentee to provide such, like technology and benefit the mankind. So that was the objective. And as you can see in India, Chapter 16 of the Patents Act, 1970, this provision is envisaged. It is applicable to both product and processes, and very similar to what Anna told that in Brazil, it only becomes applicable after 3 years of grant. So there is a similarity. Now, if you see that
Yes.
this provision was also interpreted by Bombay High Court, which is the southern part of India, in a case called Bayer versus Union of India, that when and how we will understand that compulsory license will be granted, what are the requisite grounds. So as you can see that application for compulsory licensing can only be made after 3 years of grant. An applicant must make effort to obtain a voluntary license. So there has to be a positive act by the person seeking compulsory license to first make a voluntary request to the patentee, hey, I need a license for this product for ABCDE reasons, and I believe that you are not able to manufacture at an affordable price, or it is not available to the public at large, or the patent is not being worked in India. I have the capabilities and abilities to manufacture and supply to the general public. Can you give me the license? And this provision is under Section 84(1) of the Act. Now, if you satisfy both these conditions, then the controller will consider the application for compulsory licensing. So again, my slide is stuck. Anyway, so I will go extempore. I don't think my slide is working very well. So there are three circumstances in which compulsory licensing can be granted, very much similar to what Anna told and what Dr. Ning Jiang said, that the reasonable requirement of the public has not been met, the product is not available to the public at large at a reasonable price, and the patent is not being worked in India. But compulsory licensing can also be obtained by government in an emergency situation, which can be a national emergency, extreme urgency, and also a case of epidemic or pandemic. So during the COVID period, there was a situation where government invoked compulsory licensing and not only supplied it to the general public, but also exported to other jurisdictions where the product was needed, underdeveloped country. So this provision was used at that point of time. And there is one more provision which is under Section 92A of the Act, which says for export of patented pharmaceutical products, which means there is no domestic requirement for compulsory licensing for the public in India, but there is a requirement of other country, and the permission for manufacture of a patented compound under compulsory licensing may be given so as to make supplies to those jurisdictions, and this generally applies to underdeveloped countries. Now, if you see the procedure, what is the procedure for grant of compulsory license? I'm again trying to kind of see if I can show my slide so that, you know.
If you would like, I can share your slide that you
it's okay.
with us.
It's moving.
Okay.
It's moving. It's moving. Okay. So yes. So if you can see, can you see?
Yes.
Okay. So if you see the procedure for grant of compulsory license in India, the applicant should make an effort to obtain a voluntary license of the patented invention on a reasonable terms and condition. Then in case the applicant fails, application under Form 17 should be filed to show prima facie cases are met, which is again the three conditions which I just spelled out. If the prima facie case is not made out, then application for compulsory license is served on the patentee who can oppose this application. So what happens is he will first ask the patentee voluntarily, saying that all these conditions are fulfilled. But suppose he's able to make out a case, then he has to necessarily serve the patentee that the controller will serve the notice to the patentee that I believe prima facie case has been made out, and therefore why the compulsory licensing should not be issued, and the patentee will then file a reply. And then applicant and patentee will be heard by the controller and decision will be rendered. Now, if you see, the circumstances for grant of compulsory license in India is defined under Section 84. What are that consideration of the controller while granting a regular compulsory license? So the controller looks into the nature of invention, the time of the grant, and whether the patentee has used it or not, and also looks at the same time the profile of the applicant who is seeking the compulsory license, whether applicant's ability to work the invention for public benefit, whether applicant is financially sound and have technical capacity to take on the risk and prior attempt to get voluntary license on reasonable terms. Under Section 90, wherein the terms are laid down that the compulsory licensing, while granting the application, the controller has to ensure that there are certain requirements, which is the basis of the objective of granting the compulsory licenses are made. He needs to check into that, which is whether there is a reasonable royalty or remuneration to patent, which is being paid to the patentee on the basis of invention, nature, cost, etc. Maximal working of invention by licensee with a reasonable profit, public access at affordable prices, because this is one of the conditions for grant of compulsory license. License can be non-exclusive. It is not that only one person can get the compulsory licensing. It has to be non-exclusive. It is non-assignable license. It's a very important point. It's suppose I am the person, an applicant seeking compulsory license. I cannot assign it to even to my subsidiary. So it is a non-assignable license. And license for balanced term of patent unless shorter duration suits public interest. So it can be the full term of the patent, whatever is remaining, or the controller may also shorten the period. Even if the patent is valid, it can be given for 1 year or 2 years, because the controller will decide the situation or circumstances may diminish after 1 year or 2 years of time. Then there are import restrictions. Licensee cannot import the patent if it would infringe the patentee's right. However, central government may allow import in case of public interest. There is also a provision where there can be a termination of compulsory license, and patentee can file an application for termination of compulsory license if it shows that there is no longer exist any need of the grounds which was mentioned for grant of compulsory license. Now, if you see the circumstances for grant of compulsory licenses in India, Section 84 says that reasonable requirement of public are deemed unsatisfied. So there's a deeming position if refusal to license by the patentee will cause prejudice to existing or new industry in India, demand for the product, export market development, commercial activities in India, and also restrictive licensing condition by the patentee if it hurts the trade industry involving non-patented materials, and if the patent is not worked on a commercial scale in India. So these are the parameters which will be looked into while granting or rejecting compulsory license. Now, this is a second category of compulsory licenses, which is granted only in an emergent situation. So if you see here, in India, if central government is satisfied that it is necessary for compulsory license to be granted, it may do so on national emergency, extreme urgency, public non-commercial use. In India, procedure to secure compulsory license shall not follow if the controller is satisfied that there is a case of national emergency, extreme urgency, and public non-commercial use. So as you can see, the government has a lot of powers. It can immediately, without even waiting for 3 years of time, which is in the cases of general compulsory licensing, very similar to what Anna said exists in Brazil. Again, it is stuck. So, so these are the, some of the features and the provisions under the Indian Act. I'll stop here and I will answer rest of the questions on the next round. Thank you.
Thank you so much, Manta. As we can see, we also have similarities among China, Brazil, and India. And you mentioned also an important aspect, that the importance of dedicated efforts to have a voluntary licensing. It's very important to consider this before a compulsory licensing. And also the conditions to grant the compulsory license in case of public interest, when the product is not available in local market in a sufficient manner. So very, very similar the situation, including the possibility of to export pharma products. Now let's see the examples that we have in India, Manta, please.
Thank you. Yes. So as I said in the very beginning that I have 4 cases to discuss. In one case, which is Bayer versus Union of India, compulsory license was granted. And in 3 cases, compulsory licenses were denied. And I will take you through why it was granted and why it was denied. So if you see here, this was a case of 2014, so quite almost 10 years back, for a drug, Nexavar, which is for the treatment of kidney cancer. a request for compulsory license was allowed by the controller of patent, and an appeal was filed before then IPAB, now it is abolished, and the matter went up till the court of Bombay High Court and also till Supreme Court. But before I talk about what happened in Supreme Court, let's look at why this was granted. So one of the conditions that prerequisite of efforts to obtain voluntary licenses were met. As I said in the beginning, that the applicant who is seeking compulsory licensing has to first request for grant of compulsory licensing. That was met in this case. But there was an admission which was made by the patentee that only 200 patients received the medicine out of 8,000. So therefore, the court took a view that reasonable requirement was not met, admittedly in this case, as patentee itself admitted this. And non-availability at a reasonable, affordable price was also made out. And therefore, if you see, adverse inference against patentee were drawn because it did not produce the evidence of expenditure and earning available with the patentee. Direction to produce balance sheet was opposed. The patentee declared that it is an orphan drug by the US government and it is entitled to patentee reimbursement of the 50% of research expenditure. That figure was also not disclosed, whereas the drug price was almost 2 million according to Indian currency, 2.8 million per month of therapy, whereas the genetic drug available was, you can see, less than 0.1%, so per month of therapy. So there was a huge difference in the price, and patentee failed to provide expenditure and earning justifying the cost. So the second condition, it was held that generic drug not available to the public at reasonable affordable price, and therefore the compulsory license was granted. It was also held that the product was being imported, though in India import amounts to working, but there are certain reasonable grounds which needs to be established, which the patentee failed to establish in this case. And the Supreme Court, the matter went up till Supreme Court, and Supreme Court refused to interfere with the grant of compulsory license. This is the only case wherein compulsory license was granted. After that, we witnessed 3 cases where compulsory licenses were denied. And these cases were, one of the case was of Roche of the year 2013. This was for trastuzumab, which is a drug for Herceptin. Under section 92, it was applied, saying that it is a case of national emergency and the government must notify it. The another wing of government, which is Department of Industrial Policy and Promotion, denied the fact that it was a case of any national emergency. And therefore, the two government said that, it is not a case of, like national emergency. It is a case which is trying to be built by the applicant who is trying to seek compulsory license, and therefore it was denied. The second case where it was denied was in the year 2013, where Bristol-Myers drug was dasatinib and compulsory license was applied for that. The claim was rejected by the controller of patent since this BDR, which is BDR Pharma, had not made reasonable effort to obtain voluntary license. So this is one of the conditions. As you saw in the first case, in Bayer case, this criteria was met. But here, the applicant never approached the patentee for grant of a voluntary license. And therefore, this is a mandatory requirement. If you don't seek voluntary license first, and unless it is denied by the patentee, you cannot go for compulsory licensing. So that condition was not met, and hence primary requirement was not satisfied. Lastly, this is a case of Lee Pharma versus AstraZeneca. AstraZeneca had a patent for sitagliptin, and Lee Pharma, sitagliptin is an anti-diabetic drug, and Lee Pharma applied for compulsory licensing on the grounds that price of the drug was beyond the reach of the buyer, and there is a lack of adequate availability of the drug in India. The controller of patents refused to entertain the compulsory licensing application for the reasons that Lee Pharma had attempted to secure voluntary license. This condition is made out, however, there was no evidence was produced that the public requirement was not satisfied, whereas there were several other substitutive drug, there was a lot of substituents. So there was ligagliptin, there was vildagliptin, there was so many other gliptin which were available in the market. And therefore, it was not a case where the public requirements were not being satisfied by an alternative drug. Then the next point was that no appreciable difference in current price of drug and applicant's proposed selling price. So applicant also failed to show that the drug was so expensive that it is not affordable to the patient. And the price which was quoted by the applicant was matching with the patentee's price. And local manufacturing is not always a prerequisite to establish working. No data was provided to show that the patent is not being worked. So as you can see that in India, the cases are examined very strictly following the grounds and the criterias for which is envisaged under the Act. And the applicant seeking the compulsory licensing has to fulfill those criterias, make the case, submit the evidence, and then alone, in a certain cases, compulsory licenses can be granted. I just also wanted to add here that, like China, in India also, it's not limited to pharmaceutical. You can also seek compulsory licensing for semiconductors, but there has been no case for seeking compulsory licensing for semiconductor. All the cases, as you have seen, has been in the field of pharmaceutical industry.
So thank you, Manta. So as you can see, the discussions on compulsory licenses are in India are focused on pharmaceutical area, as in Brazil. And it's also curious that in India there are conditions that are also specification on the semiconductor. It's also a very important technical area, but in India, no concrete case on this area. We will also see the importance of the evidences, either to have the compulsory license declared or to challenge this declaration of compulsory licenses. So we see that it involves extensive negotiations, and the price is one of the most important aspects. As a reference here in Brazil, we have an entity called CADE. It's an administrative economic council that is responsible to regulate the prices of the drugs. So the price of the drug is submitted to analysis and to approval firstly. So let's see as a final comment here regarding when a party is not satisfied with this compulsory licenses. So what can be done? And Manta, how about in summary, the remedies that you have in India?
So in India, it's very similar to Brazil, I would say, because any aggrieved party, whether it is the applicant for compulsory licensing or the patentee, can reach to High Court directly or can even go to Supreme Court directly, because we have two provisions. You can go to High Court, you can go to Supreme Court. However, in our experiences so far, everybody has gone to High Court and then gone to Supreme Court, because nobody wants to lose that one more, kind of a space where you can, one more opportunity to kind of take it forward. Because if you go to Supreme Court, which is the highest judicial body in the country, So people generally go to High Court and then go to Supreme Court. But strictly speaking, as per law, you can go to Supreme Court directly, or you can go also to High Court.
Thank you, Manta. So if the plan A of having voluntary license doesn't succeed, and if finally a compulsory license is declared and granted, there are tools before the courts in our jurisdictions to challenge this compulsory license. Another question, that is, in the cases discussed in the three jurisdictions, what were the royalties agreed? How were they calculated? So, Manta, would you like to comment on this question?
Yes, so depends on the facts and circumstances of the cases, but generally the royalty can range from 3% to 6%. That is an average case, but there can be a situation where the drug is so expensive and the need is so imminent that the controller may reduce it even to 1%. So it all depends on what is the situation and what is the public interest demands in a given situation, you know. So for example, we talked about orphan drug, you know, and rare disease, where it becomes generally the rare disease are very expensive medicine, and rightly so, because patentee has really invested a lot of money thinking that it will be able to recover. But rare disease, as the name suggests, the population and the patient population is so small that the demand of the product is less. And the patentee is not doing a charity. Patentee has to recover that amount from the market so as to invest for the new invention. In such cases, it becomes a very tug of war. But if the public interest prevails and the situation demands, it can be a very less royalty as well. So there is no fixed formula. It is very dependent on the facts and circumstances of the case.
Yes, so thank you, Manta. I guess you summarized it very well. The situation here in Brazil is similar, but to give a reference in terms of royalties, general from 1 to 7%, depending on the technological area, and also as a result of negotiations and the real need for the country.